Hello guys, welcome back. Last video we have completed chapter 2, that was different organs of government. Now this chapter 3 is basically related to what we studied in previous chapter. Okay, the basic powers of legislature, judiciary and executive. What are their powers that we have done in the previous chapter, and how those powers are separated equally between these three organs of government, so that they may perform their specific function allotted. That all we are gonna see in this chapter 3, which is separation of powers. So separation of powers is obviously between three organs of government, that legislature, judiciary and executive. Now objectives, this I am not going through, I am just coming to this part, concept of separation of powers. Okay, and I will begin my chapter 3 from this part. Objectives, whatever fill in the blanks and whatever exercises are given, that you need to do on your own. Okay, let's begin. In previous chapter we examined different organs of government. For preservation of political liberty of individuals and democracy, it becomes necessary in a state to establish special organs for exercise of powers. Now the powers that are provided to the government or to the people in power, it is important that to keep a check and balance and to preserve the democracy, it is important that the power may not be concentrated in hands of a few people or in hands of a single person, but rather it should be distributed to various special organs. Why special organs? Because each organ will perform its specific function that is allotted to it. Powers of government are divided between its organs in accordance with the nature of powers to be exercised. Broadly, powers of a government in a state have been classified as power to enact laws. Enactment of law is legislature power. Interpreting the law is done by judiciary, and enforcing or implementing those laws is executive. Right? Everybody knows this much. The theory of separation of powers in its simplest form implies that all above functions should be entrusted to three different authorities: legislature, judiciary, executive, being three different authorities to which these powers are separated and provided to. Three organs should be kept separate, distinct. One organ should be independent of control of others. As we know, each organ works independently. We say that judiciary is independent of legislature and executive. That means each organ should be separate and its work should be separate. That's why powers are distributed equally. Special powers or special functions are allotted to them, and it is to ensure that one organ keeps a check and balance on the other two organs, and its function is totally independent of the control of others. It's just that a certain check and balance is important for democracy to run smoothly. Each organ shall exercise its powers within its own sphere, means whatever its functions are, it has to perform those functions only which are already allotted to them. This doctrine entails that each organ shall not encroach upon or interfere with powers and independence of other organs. If any organ encroaches into train of other organ, it shall be checked by another organ of government. Thus, no new organ is created over and above existing organs of government to check encroachment. Now what happens is, each person is provided a special power, and it is said that you will only perform what is given to you. You will not step into the shoes of any other organ and try to perform its function. Okay, you can't do that. And if you are doing that, see, if one organ of government is encroaching upon the functions of the other organ of government, then to one organ is left with us, then that leftover organ is gonna see and check that whether or how that encroachment has taken place. Okay, so for seeing, for monitoring, we don't have to form any new organ of government. Rather what we have the existing three, that only will check upon that how or what type of encroachment had taken place and how to curb it, how to stop it. Okay, on the whole, separation of powers requires existence of a written constitution to define formal powers of each organ. if it is written, then it is a reliable source, right? Every time you can go to that written reliable source and say that, see, it's written over here, it's a proof that you don't have to encroach upon my functions, my arena. So in that case, a written constitution importance come into being. And separation of powers, it is very important that it has a written constitution where all its functions, all its powers are properly defined and written. Powers shall be so defined and divided to create a system of checks and balance of powers among organs. This view finds support from writings of Carl J. Friedrich, a German-American political theorist. In words of Waite and Phillips, separation of powers may mean three different things. Same persons should not form part of more than one of three organs of government, means a single person should not be in all the three organs of government. One organ of government should not control or interfere with exercise of its function by another organ. One organ should not control or should not interfere with the functioning of another organ, right? One organ should not exercise functions of another. You should not interfere, you should not perform the functions of the other organ of government, and one person should not be a part of all the three organs of the government, right? These are the three conditions which was given by Waite and Phillips regarding separation of powers. Historical background and origin. The concept of separation of powers can be traced to Aristotle. Aristotle, in his treatise Politics, called three organs of government as deliberative, executive, and judicial. So what, according to Aristotle, were the three organs of government? Deliberative, executive, and judicial. He gave the description about organization and functions of these three organs without mentioning their separation from each other. So he defined in his book that what could be the organization and functions of these three organs, but he did not define in that how those parts or how those functions of three organs will be separated from each other. In 14th century Italian thinker Macio of Padua drew a clear distinction between legislative and executive functions of government. In 16th century French philosopher Jean Bodin stated that judicial functions must be performed by independent magistrate free from the influence of monarch. So you see how historically the independency of judiciary developed when by Italian thinker Macio. He gave the distinction between legislative and executive functions, and then French philosophers said that the judge, that is the magistrate, should be free from the influence or from the control of the monarch. Okay, in 17th century British political thinker John Locke reduced from a study of English constitutional system that political power was to be divided among several bodies. So John Locke said that there should be some bodies among which the power of the government should be divided. According to him, executive and federative powers can be combined, but union of executive and legislative organs shall be prohibited to protect the political liberty of people. According to him, an ideal form of government is civil government with limited powers. So what does Locke said? That executive and federative powers means the executive and the judicial or federative powers. The federation is what? When a unit is divided into various organs. So executive can be combined with the federation, but executive and legislative organs can't be combined. Okay, to protect the liberty of the general public or to protect the democracy wherein the nation, it is important that executive and legislature, they should not combine. An ideal form of government is one in which the civil government, that is government of the people, have limited powers. Okay, they must not have an absolute power like a monarch or the autocracy, but it should be a limited power that should be provided to them, and that power should be distributed among various bodies. Montesquieu's doctrine of separation of powers, the most original, systematic and scientific elaboration of concept of separation of powers, has been given by French philosopher Baron de Montesquieu in 18th century. His theory on separation of powers has become the model for governance of all democracies. So, the most original, systematic, scientific elaboration of separation of powers was given by Montesquieu, who was a French philosopher, and he said that whatever he said about separation of powers, it has become a model for all democracies of the world. During his time, he saw oppressive and despotic rule of French King Louis XIV. Ruler enjoyed absolute powers, and prevailing dictum was, "I am the state." Liberty of people was suppressed under despotic rule of the king and his administrators. So what happened under French King Louis XIV? He was enjoying absolute powers, and he said that I am the state, I am the ruler, I am the owner of the state. Okay, I will be having all the powers concentrated in my hands only. My decisions will be the final, and the sole authority would be mine, and there could be no other person who could question that what I am performing, or what policies, what decisions I am taking, whether they are right or wrong. Nobody can question me. I am what I am. I am the sole and final authority. So that was the thinking of this French king, and in this liberty, freedom of the people was suppressed. They were not given the basic rights or basic civil liberties, were not provided to the general public. And so seeing this, Montesquieu developed that there should be a separation of powers. During his visit to England, he experienced the sense of liberty and freedom enjoyed by the citizens of England. Now he saw the condition of France under this King Louis XIV, and then he saw the condition of England, wherein the general public were given so much liberty and so much freedom. So he understood the difference, and he was very impressed with thoughts of Locke. He compared their system of governance with the system prevailing in his country. Yes, so if you are seeing some difference, he saw a huge difference. He compared the conditions of France and England, and then he was very impressed with the system that was prevalent in England. And so he examined separation of powers of government and exercised by separate organs of government, namely the king, parliament and law courts, the governance structure in England. So as I said, he was very impressed by the conditions in England. He could saw the major difference between the conditions in his own country, that is France, and in England. So he saw that how the separation of powers was conducted in England between the king, parliament and the courts. This doctrine of separation of powers emerged as a distinct doctrine in his famous book Esprit des Lois, that is the Spirit of Laws, which was published in 1748. Okay, so you just remember that Spirit of Laws was a book of Charles de Montesquieu. Nothing else you need to remember regarding this. Then we have basic features of doctrine separation of powers as enunciated by Montesquieu. Division of powers. Montesquieu does not use the term federative power for executive power in regard to external affairs. He uses the term executive to cover all internal affairs, both governmental and judicial, that is, power to apply and execute laws in particular cases as judicial power, and power to enact laws as legislative power. So what does Montesquieu said? He was not using the term federative power, कि हमने एक पावर है जो कि उसको अलग अलग यूनिट्स में डिवाइड किया. जैसे हमारे यहाँ फेडरेशन है, फेडरेशन ऑफ स्टेट्स है, तो अ यूनियन एट द कंट्री लेवल देयर इज़ अ गवर्नमेंट, एंड एट ईच स्टेट वी हैव अ गवर्नमेंट, राइट? सो दैट इज़ फेडरेशन ऑफ स्टेट्स. इंडिया इज़ अ फेडरेशन ऑफ स्टेट्स. So similarly, if power is divided into various organs of government, that can be said as federative power. But Montesquieu had not used this term federative power, rather he used the term executive to cover all sorts of internal affairs, whether it was governmental, that is legislature, or whether it was regarding judiciary. So what was the legislature pass? To apply and to execute laws, right, as judicially it does. It interprets the laws, that what could be the sense of the particular section or of the law, and then it implements it, it frames a law, right? As I told you, the example of Kerala High Court, right to internet is a fundamental right. Yes, I gave you that example also. So power to apply and execute laws, that is a special power of judiciary, so that can also be done. And power to enact laws by the legislature, all these things were under executive term only according to Montesquieu. Different departments must exercise three powers of government with their respective personnel. Their respective personnel means their respective head should be there, and in that department or portfolio only there should be the power or the function that is allotted to them. They should perform it efficiently. He provided the reason for division of powers between three branches of government as follows. When legislative and executive powers are united in same persons, there cannot be liberty. That's why we saw earlier also that there was a condition that to maintain liberty, one person should not be present in all the three departments or all three organs of the government rather. So same thing is given, that if legislative and executive powers, they are combined, and we also saw earlier that legislative and executive should not be combined at any cost. So he says that if in any case legislative and executive powers get combined, then, or if there is the same person who is in both of these organs of government, then you cannot ensure liberty. It may lead to apprehensions. Apprehension means what? डर लग सकता है, या it may be a forecast. It may lead to apprehensions that monarch may enact tyrannical laws and execute them in a tyrannical manner, as same agency becomes maker and executor of laws. So if we say that monarch is under legislature also, monarch is under executive also, then it may happen that monarch will use this power or rather he will misuse this power and enact some laws in a tyrannical way. Means in an absolute manner he will take the decision, and very brutally he will implement the laws which are not for the welfare of the general people. So this will happen because the same person is the maker of the law, and if he is making the law, obviously he will want that those laws to be implemented in the nation, in the society. So the same person would be, agency means person, the same person would be the maker and executor of law. So there will be no liberty, because it may happen that monarch, who is the person in legislature also and executive also, he will be making the laws, making tyrannical laws, and he also wants then that if I am making the law, I will want it to implement it. So he will also implement those tyrannical laws in a tyrannical manner, and that will not be for the welfare of the society. Where judicial powers are combined with legislative, life and liberty of subjects would be exposed to arbitrary control, as judge would be the legislature. Now in case when judiciary and legislative powers will be combined, life and liberty of general people again will be at stake, because now the people or the citizens of the nation will be exposed to arbitrary control. Because now what will happen if judiciary is combined with legislative? The judge would be the legislature, he will make the laws, right? So it may happen that he will make some arbitrary rules which will not be for the good for the general public at large. Judicial power combined with executive power, judge might behave in a violent and oppressive manner. Prosecutor and judge would then be the same person and authority. So if we combine judiciary and executive, then also the judge would behave in a violent, oppressive manner. He may act to oppress the liberties or rights of the general public, and so it will not be for the welfare, because the prosecutor means the who grants punishment, and judge who makes laws will be the same person. So it is not good that any of the three organs functions should be combined with each other. If powers are vested in one organ or exercised without separation, governance would not be effective. Okay, so basically these 4 points suggest that there should not be any combination of any two organs of government, or rather three organs of government. They must act separately and perform their own functions which are given to them, to ensure that governance is smoothly and efficiently going on, and also for the welfare of the nation at large. It is inherent in any authority to abuse powers unless limitations are imposed on its exercise. So we very well know, if we are giving a power to somebody, then there are chances that he is gonna misuse the power, right? So it is important that certain limitations or certain restrictions are put upon him, and certain checks or control or monitoring is done, that he may not misuse the power that is provided to him. For safeguarding liberty of people, each organ shall have obligation to act within its own sphere and not beyond it. If authority acts beyond permitted limits, it would be checked by the other organs. This means that executive organs shall exercise some control over legislative and judiciary, legislative over executive and judiciary over legislative and executive organs. This system of checking encroachment of powers by each organ and balancing division of powers is termed as the system of checks and balances. So one organ can keep a check on the other two organs, and so the case happens, and this system is known as checks and balances. I have already explained you earlier also in this video itself that if there is an encroachment by executive on the powers of judiciary, then the third organ that is remaining, that is legislature, it can keep a check, it can monitor or observe that how the encroachment has taken place and how to curb it. That also be seen by the third organ which is left. So we do not need to form a separate organ or separate committee to see that how or what type of encroachment has been done. The three organs, third organ only will be seeing that what sort of encroachment has taken place, and to curb that it may also take a decision. So balancing division of powers, keeping check and balance, control, monitoring, all that is done between these, among these three organs only. So that's why this is known as a system of checks and balances. This kind of overview is the correct meaning of maxim pure vertere le pavor. Now whenever maxim comes, as I told you, it is very important, which means power holds power. Holds means stops. These three organs are given their separate powers and they are only keeping a check on the other organs. So power holds power holds true in this case. By separating the functions of executive, legislative, judiciary, one power may operate as a balance against another and thus have a check on the power exercised by another. Okay, so checks and balances of power, this C part I will be taking in the next lecture. This is all for today's lecture. Thank you so much.